Okay, some more information on Florida drug laws. This lecture segment is titled Drug Charges Defined under Florida Law. And what we see is possession of narcotics, illicit substances, prescription medication under Florida law mandates that when we're dealing with prescription medication in particular, we're dealing with a controlled substance that requires a valid prescription issued by a licensed physician in order for the person possessing the substance to be in compliance. Florida criminalizes the possession of pharmaceutical medication without this prescription. Not only that, it's required that the prescription being held by the accused conforms with the type of medication that was actually obtained. So what you need to remember here is that the prescription and what was obtained from the pharmacy has to match up with what substance was found on an accused. If an accused lawfully obtained medication in the form of generic pills of a certain milligram, yet was found with the same controlled substance, and it was not generic, or it was not the same milligram, well, then the prescription is not what was used to obtain that particular substance, and that person can be charged with a felony under Florida law. Now, our drug laws in Florida apply to two types of illicit substances or controlled substances: those intended for a medical purpose and those that are not. We have cocaine, which you cannot get a prescription for, and other substances that do have a medical purpose, such as hydrocodone, oxycodone, Xanax, Adderall. This is of no consequence ultimately. A prescription medication, although it can be lawfully possessed, still carries felony charges if it's not possessed with a valid prescription, and it is treated as being just as illicit as something like cocaine or heroin. Florida also makes it a criminal act to possess drug paraphernalia, which is a device that is used in some connection with an illicit substance. Products or materials designed for use or intended for use in the manufacturing, compounding, converting, producing, processing, preparing, testing, analyzing, packaging, repackaging, storing, containing, concealing, transporting, or even using an illicit substance may be found to be drug paraphernalia. Drug paraphernalia is a misdemeanor in Florida. Most often we see situations where the paraphernalia is designed in some way to ingest a controlled substance. In Broward County, what we started seeing about 15 years ago was the state attorney's office taking an individual who had been arrested for possession of paraphernalia, and this was most often in the case of crack cocaine pipes, which is a misdemeanor, but they would scrape the inside of the crack cocaine pipe and take the residue and test that. If it tested positive for cocaine, they would then proceed forward on an additional count of possession of cocaine. Possession of crack cocaine is pursued by the Broward State Attorney's Office as possession of cocaine. Some people think that there's a difference, but there is not. These cases are highly defendable, of course, but still, you go from a misdemeanor charge to both a misdemeanor and a felony with a prosecutor's office that does something like scrape the inside of a crack cocaine pipe. Under Florida law, it is obviously a crime to possess a controlled substance with the intent to convey it or to sell it. This falls under an enhanced or a higher classification of felony under Florida law. Delivery charges are generally second-degree felonies, and trafficking charges can stem from possessing a certain amount of a controlled substance, which is determined by the weight in Florida. For the state to bring a trafficking charge, there does not need to be any evidence that the individual intended to sell or deliver to someone, but rather just the weight alone. Controlled substances in the form of medication fall in this category, just as cocaine or heroin would. Now, in recapping, if somebody possessed a controlled substance and it was individually packaged, and there was a certain amount, and there was money and a firearm and some evidence to indicate that this person was going to sell the prepackaged controlled substance, well then the state attorney's office may elect to bring delivery of a controlled substance or delivery of cocaine, delivery of hydrocodone. Absent any of those facts, the mere possession of a certain amount of pills, let's say OxyContin, a bottle of, let's say, 110 of them, alone could give rise to a trafficking charge if those pills are possessed absent a valid prescription and the aggregate weight of those pills meets the threshold amount. No other evidence is required by way of an intent to deliver or convey these substances. When we say the aggregate weight in Florida, what we mean is that the weight of the individual pill or substance, meaning that pills that are larger or weigh more carry with them a greater risk that a trafficking charge can ensue. The milligram, the potency, the amount of actual pure grade controlled substance in the pill is of no consequence. The same holds true with trafficking in cocaine charges, where the cocaine is cut and cut and cut and mixed, some type of additive, which is commonly done on street level sales to be able to get more quantity of the product to sell. The more potent the cocaine is of no consequence when it comes to weighing and charging an individual for possessing and trafficking in an illicit substance. Now, traditionally, we think of drug trafficking as involving an individual who knowingly sells, purchases, manufactures, delivers, or brings into the state of Florida a controlled substance. But what I want you to remember is that in Broward County, our trafficking arrests and prosecution almost exclusively involve people possessing controlled substances in the form of medications that reach a certain amount, a certain weight that brings them into a trafficking range, regardless of any other evidence in such cases where somebody does not have a valid prescription for same. Remember, when you do not have a valid prescription, being in possession of prescription drugs such as methadone, oxycodone, OxyContin, hydrocodone, alprazolam, which is Xanax, that is all illegal in Florida, and they all carry felony charges. When you think about a misdemeanor drug offense, I want you to think about marijuana. It's a good rule of thumb to think of all other controlled substances as bringing felony charges when possessed. Now, it only takes a few pills of even prescribed medication to get into a trafficking range. And this is a result of the evolution of our drug laws in Florida. We've seen great efforts on the part of law enforcement in Broward County and the state of Florida to control, to curb the effects of the pain clinics that started popping up about a decade ago. And recent legislation has done a significant job in curbing the effects that pain pills and pain clinics have had on our society. My name is William Moore.